Hello everyone and welcome. My name is Joe Marciniak and I'm the Electronic Resources Librarian for Princeton University. So just to make sure everyone is in the right place, here is the session abstract. This session is primarily meant for library personnel who are responsible for reading, negotiating, and signing license agreements. Now would probably be a good time to mention that I am not a lawyer or attorney or any other title required to give qualified legal advice. No information or details in this presentation or the discussion that follows constitute legal advice. So, if I'm not a lawyer, then why am I presenting on a legal topic? What are my qualifications? The only qualification I can offer is my experience. I've been processing license agreements for about 10 years now, and I recently started tracking and recording the information I have learned along the way from vendors, vendor legal departments, in-house purchasing and legal departments, and colleagues. I've been collecting and organizing this information to help me process license agreements more quickly, and I figured it would be useful to others as well. Before we dive in, I wanted to share a few details about my perspective and background. My institution is a private academic institution with an FTE of 8,424 and 1,295 faculty members. The library has a large collections budget to support electronic resources acquisition, and I work directly with about 50 subject specialists or selectors to acquire new e-resources. The workload is significant, and with every new acquisition being accompanied by a license agreement, I had to learn to process license agreements as quickly as possible. Now, some libraries have dedicated personnel just to process license agreements, but at many institutions, the responsibility of processing license agreements falls to the e-resources librarian simply because license agreements accompany e-resources purchases and subscriptions, so they become a part of the e-resources lifecycle and management workflow. Let's take a quick look at an outline of today's session so you know what we're going to cover. During this presentation, I will be simplifying and summarizing complicated content for the sake of time and clarity. You can then use this information to investigate topics more thoroughly. Today we'll cover the purpose of a license agreement, the common structure and how to navigate an agreement, authorized users and uses, prohibited uses, fees and payments, governing laws and indemnities, negotiating with vendors, patron awareness, and where you can get help. So let's just start with the purpose of a license agreement. The main purpose of an agreement is to protect the interests of both the licensee and the licensor. The licensee is you, and the licensor is the vendor or information provider. Your interest is that your patrons have access to the content for academic research and educational purposes, and the vendor's interest is to protect their product so their ability to market and sell it to other institutions is not negatively affected. Again, I'm simplifying here. License agreements can vary in length and complexity. Some license agreements are just 1 or 2 pages, while others are over 30 pages with tiny font that you will have to enlarge just to be able to read. But one helpful aspect of the license agreement is actually its structure. Like scholarly articles, license agreements are tightly organized, and each section has a heading that provides the context for the information in the following clause. License agreements can certainly vary, but the most common structure you will encounter contains a glossary or definitions of terms, sections about authorized users and authorized uses, prohibited uses, a statement about ownership, information about access and authentication, fees and payment terms, licensee and licensor obligations, and warranties and indemnities. And there's usually a section at the end that's labeled general or miscellaneous. Our focus today is going to be on clauses related to who has access to the information or product, how the content can be used, payment and renewal terms, and the licensee's obligations. Other than the permitted uses clause, the authorized users clause is the most important from the service perspective of the e-resources librarian. It's an important clause because it defines the users who can legally access and use the content. As librarians, we advocate for the broadest, most inclusive definition of authorized users possible. You will typically see an AU clause reference current faculty, students, and staff, but what about visiting researchers, contractors, alumni, and walk-in patrons and community users? These are all groups that we want to see represented in a license agreement. Here are some examples of definitions of authorized users. You can see that some of these examples are restrictive. The top one mentions employees and students. The second one explicitly states that walk-in users are not authorized users. And the third one only mentions staff and consultants. Most of the time, when you see restrictive definitions of authorized users, the provider is not used to dealing with an academic customer. You'll see these primarily with legal and financial electronic resources. One of the points of negotiation with a provider can be to expand the definitions of authorized users to make sure your entire user population has access. It's not always possible, but it's always worth asking about. These definitions of authorized users are quite broad. They include independent contractors and walk-in users. The second one also mentions other valid ID holders, which is a very broad definition and leaves discretion up to the library. The most unrestrictive definitions of authorized users are the ones that leave it completely up to the institution to determine whether or not someone should have access based on the library's own criteria. These three examples grant authority to the licensee to determine the eligibility of patrons to access the content based on their internal criteria and policies. So you can see that these are the broadest definitions of authorized users and therefore the most ideal for libraries. Most students and staff are surprised to find out that they actually lose access to library e-resources once they become alumni or retirees. Alumni in particular expect continued access, and our library has been able to negotiate alumni access to a few e-resources, but most vendors do not permit access by alumni. If you do the math, take the number of graduates from your institution each year and multiply that by a few decades, and you can see how the number of active users could quickly become very large. Most license agreements don't specifically mention retirees, but they are always excluded by omission because the clause will usually specify current staff and faculty. If a patron group is not specifically mentioned in the authorized users definition, then you have to assume that they do not have access. Another important clause is the community users or walk-in users clause. Allowing community patrons on-site access to library e-resources is central to the mission statement of many libraries, and it is important to continue providing access to this group of patrons. Keep in mind that license agreements might not use the terms community user or walk-in patron, but if the agreement states that people can access the e-resources while physically present in the library, as this second example does here, then that does include community users. But you probably noticed in the example on the previous slide that walk-in patrons / community users were not permitted access to that particular e-resource. So you need to make sure it is not accessible to walk-in patrons, and you would need to communicate this restriction with relevant library personnel such as the reference department or circulation staff. Like the community users clause, the ILL clause is central to the values of librarianship. As I assume we all know, ILL stands for interlibrary loan, and it is the very common practice of libraries sharing a limited amount of content with an authorized user affiliated with a different library or institution. Most agreements explicitly state ILL permissions, but if your license does not, you will want to attempt to add it during the negotiation phase. So, after you have reviewed the groups that will have access to the content, you then want to pay close attention to how they are allowed to use the content. The permitted uses or authorized uses clause outlines how patrons are legally able to use the content. It is very common to see a permitted use clause like this one that lists research, internal evaluation, and educational purposes. I always confirm with the vendor and edit the agreement to explicitly list non-commercial publishing as a permitted use. Vendors often say, well, non-commercial publishing is included in research or educational purposes, but I like to have that reflected in the license agreement explicitly. The phrase commercial purposes is a bit confusing if you think about it too long, because authors do receive compensation for their scholarly output, that is, articles and books. But every vendor I have discussed this with has assured me that that is not what they are referring to when they refer to commercial purposes, and I'll show you an example in a minute of this. So from the library's perspective, we want to make sure that our patrons can use the information in their research, which might include publications they are paid for or compensated for, and we want to make sure they can present insubstantial amounts of data or information in their publications as long as attribution is given. One question a lot of faculty members have is, can I send an article to a colleague of mine at a different institution? If the governing license agreement has a clause like this one, then you can confirm that sharing is permitted, but I always advise patrons not to send more than one article to a colleague from a single publication. A few articles would probably be okay with the publisher or vendor, but I try to err on the side of caution. You want to avoid any amount of sharing that could be considered a substitute for another customer having to obtain their own paid access to the content. So now we know who can access and use the content and how, but what about the prohibited uses and activities? Many license agreements have clauses like 4.1 here that prohibit users from removing information or altering information on the licensed material. This is common, but it's really impossible for the library to enforce. We also see reference to systematic activities such as printing or downloading outside of what is approved in clause 3.3. Notice also that 4.3 prohibits authorized users and walk-in users from electronically distributing copies of the licensed material to anyone outside of the organization. This is the opposite of the scholarly sharing clause that we just took a look at. Another common prohibited activity has to do with authorized users decompiling, reverse engineering, or disassembling the licensed content. This clause is included to protect the licensor from an authorized user using the content to develop a competing product. The second example provides clarity about what is meant by commercial purposes, and you can see that they are primarily concerned with licensees reselling the content. The last sentence is interesting because it forbids imposing special charges for access beyond reasonable printing or administrative costs. Your library or one of your branch libraries might actually charge community users for access to the building, and while we assume this falls under reasonable administrative costs, it's always good to confirm this with the content provider. One of the most common prohibited uses of an e-resource is automated or systematic downloading of content. E-resources are intended to support traditional definitions of research activities and not to create custom data sets for text and data analysis. So what do I mean by traditional definitions of research? Basically, I mean reading, right? If a patron is scraping data from a website or downloading 500 articles in 20 minutes, whether manual or automated, then that activity will be detected by the vendor and your institution's access will be suspended, as happens to us a few times each year. It's important to note that we haven't actually had our system compromised. It's just that many patrons these days are tech savvy and they aren't aware of these restrictions on e-resources, which is why it is important to communicate restrictions to patrons, which we'll talk more about soon. Finally, here are two examples of a very clear prohibited use that states the licensee cannot use the licensed product to develop competing products or pose conflicts of interest. Note that the top example is at the sole judgment of the licensor. These examples reflect what I mentioned earlier about providers needing to protect their interests. A company needs to be able to market their product to multiple customers in order to survive. You'll also want to pay attention to the renewal and cancellation terms. If you use an LSP or ILS, input this information into that system so you can generate a report about when a resource needs to be reviewed. This will give you plenty of time before the renewal in case you do want to cancel. 30 days notice is common, but you will see 60 and even 90 days notice as you see here in the second example. The Governing Laws Clause stipulates the legal jurisdiction that disputes will be resolved in. Sometimes vendors cannot change the Governing Laws Clause, but they can actually remove it and make no specification at all, or what they call going silent on a certain clause. So if you can't have them change the governing laws to your state or preferred jurisdiction, ask if it can simply be removed from the license agreement. One of the most difficult aspects of the license agreement to understand is the warranties and indemnities clause. But here are a couple definitions that I think can help clear it up. So warranties in a license agreement set out the promises that parties have made. For example, the content owner warrants that he is the owner of the content he is licensing to the library. Coupled with this warranty is an indemnity clause which sets out that should the warranties not be upheld, that the licensor or licensee will compensate the party for any resulting expenses due to broken warranties. And a good short definition of indemnity is one party's obligation to ensure, shield, or otherwise defend another party against a third party's claim that results from performance under or breach of the agreement. Here's an example of an indemnity clause. Again, this clause basically means that if a third party brings a claim against the provider, you would want to be protected from that claim by the provider. Likewise, if your organization, a patron, violates the terms of a license agreement which results in legal action, you agree to shield the provider from the claim or accusation. If a provider asks you to indemnify them in a license agreement, always make sure that you are also indemnified. License agreements can also contain information about privacy statements and terms of use. Usually these are links embedded into the license agreement, which take you to a web page and can make them hard to track and edit the license agreement. One question I constantly ask is, how can I or the library accept a privacy statement or terms of use on behalf of a patron? So for e-resources that are not providing anonymous access to all of your patrons, the ones where a named account is required, or maybe you're using SSO authentication, that single sign-on where information about your patron is passed to the provider, I always make sure to confirm with the vendor or the provider that the patron will actually be exposed to the privacy statement or terms during the registration or access workflow. It sounds obvious and simple, but you would be surprised how many times a provider has not even considered this and does not present those terms to a patron. We want to make sure that the correct party is accepting the terms that are actually affecting how their private information is being used. So we've looked at important clauses like the authorized users, the permitted uses, the prohibited uses, ILL permissions, renewals and cancellations, governing laws and indemnities, privacy statements and TOUs, and now let's look at some license negotiations. First, always include your account manager or sales representative on request to amend or change the language of an agreement. Although they are not the ones who can make the decision, it is important to keep them involved in the process, and they are invested in a different way than, say, a vendor's legal department. After all, they have the most interest in making a sale, and it's important for them to know what your values and concerns are as an organization or library. Keep in mind that negotiations can take a long time, so that's one of the reasons to start reading or processing license agreements as soon as possible. For large vendors with in-house legal departments, it can take weeks just to receive a reply to your request for changes. One of the most common requests I make is to remove payment penalties. At my institution, we are not permitted to agree to any late fees or interest accruals for late payments. We make every effort to pay invoices within 30 days of receipt, but we cannot pay an additional fee if we cannot make payment within a certain time frame. As I already mentioned, I also regularly request to have governing laws removed or changed to New Jersey. I ask to add language that explicitly permits academic publishing, and I work to add additional authorized users such as walk-in patrons, contractors, and sponsored researchers to the authorized users clause. If a vendor is not able to accommodate a request to remove content from a license agreement, you will need to pursue alternative language that satisfies both parties. As you work more and more with license agreements, you'll be able to suggest alternative language, and it's a good idea to keep examples organized in a document for future negotiations. But in the beginning, it's okay to ask the vendor to provide some alternative language. Ask the vendor if they have a softer or broader version of a clause that you are unable to agree to. Here's an example of what we mean by softer language. Instead of stating what a client will do, the language is softened to state what the client will attempt to reasonably do. This is helpful with many clauses that ask the library to do something they cannot really do. It basically means that should the library become aware of a certain issue, they'll do everything they can. In this example, we were able to soften warrants and represents to best efforts. We don't monitor patrons' ages, and we don't work with legal guardians, but we could agree to use our best efforts to make sure that AUs are over the age of 13 should we become aware of a patron's age. Here's an example of a clause I came across, and I'll give everyone a moment to read it. The part that gave me pause here was the use of the word copyright. A permitted use of this e-resource was academic publications, which are copyrighted by authors. I then took this clause to mean that a vendor would have full rights to the copyrighted work if it included information from this vendor's product. So I simply contacted our account manager to make sure I was understanding this clause correctly. Never worry about just asking a vendor to explain a clause or provide additional information to make sure that you understand the terms. And in this case, I was glad I did ask the vendor because they were actually able to provide this alternative language and additional explanation. It turns out that they were concerned with AUs developing competing products and services and had nothing to do with what I was thinking about, that is, copyrighted academic publications. We were able to update the document with this alternative language and sign the agreement. If negotiations do fail, don't panic. Clearly communicate with the stakeholders and explain what the issue is that is preventing you from moving forward with the license agreement. Your best ally is usually your sales rep or account manager because, as I mentioned earlier, they want to make the sale. But if the vendor is not willing to budge and you still want to acquire the e-resource, it's time to talk about acceptable risk. I learned this term while working with our purchasing office, and it basically means that the risk of an issue arising is so low that we could go ahead and sign the agreement as is. Every organization will have a different tolerance for risk, so be sure to discuss this with colleagues if you find yourself at an impasse with a vendor during the negotiation process. Sometimes negotiations don't technically fail because they never actually start. Some vendors will openly state that they do not negotiate individual license agreements, but it's always worth pursuing anyway. All they can do is tell you no. Typically, you will encounter this with very large organizations that post their license agreements openly on the internet. To negotiate with them, they would have to draft a custom agreement just for your institution, which they are usually not willing to do. During a recent subscription renewal, the provider stated that they could not make any changes to the license agreement, and that all of their subscribers were required to sign the exact same agreement. In this case, we had to apply the acceptable risk tag in order to renew the resource. As many of you can probably guess, the most common violation of a license agreement has to do with automated or systematic manual downloading. Many researchers today want raw data or custom data sets, and because they have the technical ability, they set out to excessively download content or build programs that will download, scrape, or crawl websites and platforms. Once the vendor flags the excessive usage coming from one of your IP addresses, they simply disable your access and send you an email about the unauthorized activity. Meanwhile, your entire institution loses access to the content because of a single patron's actions. So how do you resolve these issues? Well, the vendor should provide a log file with as much information as possible about the violation. That will allow you and your IT team to investigate and identify the person responsible for the activity. Next, you will likely have to interview the patron to obtain an explanation and confirm that there was no malicious intent. At my institution, this is handled by a copyright compliance officer, so it's all confidential. I'm often not even aware of the patron responsible for these activities. Then you need to communicate with the vendor, and if they are satisfied with the explanation and sure the activity won't resume, they will restore access to your institution or IP addresses. Needless to say, it is a time-consuming process and affects the access of all of your patrons. If this occurs during a busy time of the semester, such as final exams, this can be a very stressful process. Now, if license agreements are boring to us, imagine how interesting they are to library patrons like students. The challenge is how to inform them of the limitations of access, especially when patrons access content from many different avenues and paths. Like most libraries, we have an A to Z resource list, so we chose to post information about permitted and prohibited uses on each entry, or access point. There is, of course, no guarantee that patrons will notice and read this information, but it's important to be able to demonstrate that you do have it posted openly at your access points. This is often necessary to satisfy the terms of a license agreement that require you to communicate this information to patrons. Many license agreements will include a clause that requires you to expose terms of use to your patrons, so you will need a way to show that you are compliant with this request. Now, it's rare, but you might find yourself in a position where a provider actually asks you for a license agreement. Usually this occurs when you are dealing with a small or new company, and it is good to be prepared should the situation arise. We recently acquired a custom dataset from a vendor, and they asked me if we had a license agreement for the acquisition. I drafted this agreement, and you can see that it focuses on the key elements that I am concerned with, that is, who can use the data and how they can use the data. The AU clause is broad, including affiliates and sponsored researchers, and although users are required to cite the information appropriately, the university is not held responsible if they do not. It's another one of those things that we really just can't enforce. I also included information that protected the vendor against claims related to the completeness of the quality of the data and against computer viruses, etc. Does it include the complexities of warranties, indemnities, intellectual property ownership, etc.? No, but it got the job done and it satisfied our needs as well as the providers. I did want to mention that the Library of Congress has a freely available model license, which you can see here. At 16 pages, it's very thorough and easy to adapt to your library's needs. Don't forget that many license agreements are confidential, so do be careful about who you involve in the negotiation process and who you seek advice from. It's likely that someone else at your institution or organization also processes license agreements. There might be a purchasing office or a legal department, and it's worth trying to form relationships with those personnel for assistance. If you work for a state institution or government institution, there is also likely documentation about what you can and cannot agree to in a license agreement. I used to work for a state university, and there was reference documentation available from the state that outlined what was acceptable and not acceptable in a license agreement. So, despite the purpose of my presentation, which is to help you quickly understand, negotiate, and navigate license agreements, there is actually no substitute for close reading. As you process more and more license agreements, however, you will become a proficient skimmer, but keep an eye out for new clauses that might pop up suddenly. Recently, I've seen clauses that would have given a vendor access to our IR, or institutional repository. I've seen solicitation clauses that forbid us from soliciting or recruiting vendor employees, anti-bribery and anti-corruption clauses, and clauses that discuss human trafficking. Recently, I read a clause in a custom dataset license agreement that stated that the vendor could have access to the user's personal research environment, their computer equipment, and home office for auditing purposes. When I told the vendor that we could not agree to the clause, their response was, "Oh, we've never enforced that." Well, that might be true, but if it's in the license agreement, keep in mind that it is a legal obligation. So if a vendor doesn't plan to enforce a clause, it should just be removed from the agreement. So in terms of takeaways, I would emphasize using the license structure to your advantage. The headings in the organization will provide context for the content and make it easier to understand. Focus on the clauses related to authorized users and uses, prohibited uses, payment and cancellation terms, governing laws and indemnities, and your obligations under the license agreement. Again, you'll see some license agreements that are 30 plus pages, so even though this sounds like a lot of clauses to focus on, it's really not when you get to the longer agreements. And also develop those professional relationships that will help you process licenses. If you don't have anyone at your institution that can be identified, start contacting other people at other institutions that also process license agreements and form those relationships so that you can rely on each other when you have questions. Now, I know that was a lot of information, but we do have time for some questions now. Also, feel free to email me with any questions or comments you have. Here's my contact information. Thank you very much for attending my session.